Mr. Lickidopoulos.
My lords, I appear for the appellants, Neurim Pharmaceuticals, and my learned friends, Mr. Van Heegen, QC, and Mr. Beebe, appear with the respondents, and my learned friend, of course, with me here is also for the appellants. May I first thank the court for accommodating, I think, both of my learned friend and I with timings and starting now at 2 o'clock, and agreeing to perhaps sit until 4:30 if we need to, but unfortunately I can't stay later than that, my lord, for reasons of medical appointment.
Just pausing there, the message had come through to me that actually it would suit everybody not to go beyond 4:15 today.
It would certainly, I won't want to trespass on the call, but it would certainly suit me. I've got to get to an appointment at 5:15, so I was have a control over.
Well, perhaps as we come up to 4:15, we can review what to do about tomorrow morning. If necessary, as I think you know, we could start a little early, say up to 10 o'clock. But of course, if it proves not to be necessary, then so much the better.
Of course, my lord. Thank you. My lord, there are two appeals. One relating, in effect, one relating to whether or not Flynn was granted an exclusive licence under the patent. And the second concerns the judge's decision to award Mylan all of the costs of the action, despite Mylan losing on the issues at trial, save for the exclusive licence point. I'm going to first, this afternoon, deal with the background relevant to both appeals relatively briefly, and then I was going to consider first the exclusive licence appeal, and then the costs appeal in the order that the parties have dealt with in writing. My lords, with background, the action concerns a medicinal product marketed and sold by Flynn Pharma, which is known as Circadin, and the dispute arose with Mylan's decision to launch a generic equivalent to Circadin or Circadin prior to patent expiry. The patent was to expire in August of this year. Circadin is a prolonged release tablet formulation. We don't on this appeal need to get into the science of it. It contains melatonin and is used to improve restorative quality of sleep in a patient suffering from primary insomnia, characterised by non-restorative sleep. I will show, my lords, in a moment the patent claim and the marketing authorisation, since points arise on that on the exclusive licence appeal. Circadin received marketing authorisation in June 2007, and in November 2011, Neurim granted Flynn a licence to Circadin in the UK and Ireland in respect of any of its patent rights that would cover it, and I'm going to show you that in a moment. Now, in May 2017, the patent, the subject of the trial, the 702 patent, granted, and if I may now show you the patent claim, just because it may arise later on the exclusive licence point, my lords will find that in the supplemental licence bundle, tab 21. And I think for the purposes of this appeal, we can take it just from the claims, which my lords will find on page 332. And my lords will see the claim is to the use of a prolonged release formulation comprising melatonin in unit dosage form, and as granted, it had a broader milligram dosage, and that was then amended at trial to being 2 milligrams of melatonin. And then you see it's characterised by non-restorative sleep, and the other amendment was in patients aged 55 years or older. The reasons for going for that, looking at that, is then to look at the marketing authorisation of the product Circadin, the subject of the exclusive licence, and that, my lords, will find in tab 17 of this same bundle, page 309. And my lords will see there again it's a prolonged release tablet of 2 milligrams melatonin, and then on therapeutic indications it's a monotherapy for short-term treatment of primary insomnia, and says characterised by poor quality of sleep in patients who are aged 55 or over. And for my Lord's note, if it matters, the judge held that this reference to poor quality of sleep was equivalent to non-restorative sleep of the claim, and that was the trial judgment, paragraph 53, little 3, footnote 62 on page 137. And originally Mylan had said there was a difference, but actually then abandoned that point, and one can see that in the deleted defence and counterclaim in core tab 16, paragraph 5c. Now, Mylan and others commenced an opposition at the EPO, and at a hearing in November 2019, the opposition division held the patent was anticipated by a document called HAMOV. Neurim appealed, and as my lords will know, under EPO procedure, that means that the effect of the opposition division's decision was suspended, and Neurim's position was and remains that the opposition division was wrong on anticipation. Because it had found the document, the patent anticipated by HAMOV, the opposition division didn't consider any other grounds. As my lords may know, that is also fairly typical of the way the opposition division proceeds. So validity was at large, and in December 2019, Mylan obtained marketing authorization to launch a generic version of Circadin, and Neurim wrote asking what the plans were in respect of launch. And Mylan made clear that it was not intending to await the outcome of the EPO appeal and intended to launch in the UK at risk, and indeed it did so in September 2020. And that caused my clients to commence these proceedings in February 2020 and to apply for an interim injunction in March. Now, also in March, my clients wrote suggesting a stay pending the EPO, and it's worth looking at that. That's again in the supplementary bundle at tab 15. This correspondence is relevant to the cost side of the appeal rather than the exclusive licence side of the appeal. But as part of the background, in March, my lord should have there a letter of 9th of March 2020 from Gowling, and you see in the first main paragraph that they disagreed with Mylan's position that it had taken appropriate action to clear the way. That was a reference to starting an EPO opposition. However, if you are in fact of the view that EPO proceedings are a proportionate and cost-effective way to clear the way in the UK, it would follow you will agree to delay any UK launch pending the outcome of the EPO proceedings. In that event, our client and Flynn Pharma would agree to the UK proceedings being stayed pending that outcome, and all parties would save significant costs. Please let us know if you would agree to this arrangement. They did not agree, and you see that in the next tab 16 in their response from Taylor Wessing on the 11th of March, where they don't agree the proceedings should be stayed. They considered the patent to be invalid, considered the opposition division to be correct, because the EPO timelines were uncertain, and Mylan's view is that a speedy trial in the UK is now regrettably the most appropriate way to proceed, and therefore they enclosed order for directions for an expedited UK trial, and that is what happened.
Now, just pausing there, am I right in understanding that neither party addressed the question of a cross undertaking? So it was not part of your proposal you would give them a cross undertaking if they kept off the market pending the EPO, but equally they didn't suggest it in their reply.
My lord is right. As far as the correspondence went, if you go back, my lord, to tab 15, you'll see in the paragraph that is numbered 1, the proposal was that they undertake to stay off the market until the infringement proceedings are finally decided, or until the outcome of the EPO proceedings, if they agreed to paragraph 1. So,
sorry, where are you?
Oh, sorry, in tab 15, the letter of 9th of March. There's a paragraph headed little 1.
Right.
And you
mean
see
headed your first letter,
yes,
numbered 1.
Sorry, my lord is absolutely right. And you see 4 lines down, it says, unless your client undertakes to stay. Now, I accept that's not the point you put to me, which was us offering a cross undertaking. But we did say you undertake to stay off the market pending the EPO, or pending the UK, and they came back saying no, but they did not come back and say, but we would if you offered a cross undertaking.
Yeah, so neither side raised the question of the cross undertaking.
My Lord, then, following that, we filed our grounds of appeal at the EPO and agreed to expedition of the EPO. And the interim injunction application was heard by Mr. Justice Marcus Smith in May, and judgment was given in June. And he refused the injunction. My Lords would have seen that, interim injunction. He held that damages would be an adequate remedy for both parties, and as the Court of Appeal pointed out when it was before them, that by the time of the interim injunction hearing in May, the UK trial had been expedited to October, and that short time for trial put a different complexion on harm that might be suffered, whether it be unquantifiable. Following this, the parties continued to prepare for the UK trial, and on the 3rd of June, the EPO set a hearing date in December 2020. Now, reference was made to that at the PTR, but neither side requested a stay. And since then, Mr. Justice Mead has made clear that there is a duty on parties to do so, even if neither wishes to ask for an adjournment. And for my Lord's note, that is in his judgment in the Joint Authorities, tab 15, page 197, paragraph 181. The UK trial went ahead, 29th of October to 5th of November 2020. Actually, just after it, the EPO postponed the hearing at the EPO to July 2021, but then later reinstated it. I think, I'm not entirely sure, but I think at the time it was linked to the problems the EPO, difficulties the EPO were having with COVID type arrangements. And the judge handed down judgment in December, and as I'll come to later when I look at the judgment briefly, the judge rejected all of Mylan's invalidity arguments. And he held the patent was valid and infringed. The only issue on which the appellants were unsuccessful was whether Flynn was an exclusive licensee under the patent, and that's the subject of the appeal today. Now, at the form of order hearing in December, the judge made the usual orders following a finding of valid and infringed, and awarded the appellants all of their costs, save for the exclusive license issue. And my Lord will find the December order set out in the judge's March judgment, because it wasn't finalised, and the judge set it out in core bundle. This is now the main core bundle for the it's called license core bundle. In tab 12. Page 212, bundle page. And there, in paragraph 36, little 4, the judge summarised the order that he had made on the 16th of December, and A to H would be the relief that one would expect, or often expect, following a finding of a valid and infringed patent, the relief provided for under section 61 of the Act. And then little I is costs, where he awarded my clients their costs, subject to a deduction on the exclusive licence point. And then he gave permission.
We can see from F that the injunction was not to take effect until after the conclusion of the Board of Appeal hearing, and subject to it lapsing in the event of Neurim's being unsuccessful.
Exactly, I was about to say that.
So he was well aware of the possibility at that stage that, notwithstanding the fact that he had upheld the claimant's claim, nevertheless, it might all disappear in a puff of smoke.
That is right. And as I'll show you when we come to the cost side, he discusses this in his later judgment, that he was aware. There's no suggestion that the judge wasn't aware when he made this order about the EPO proceedings.
Yep.
On J, permission to appeal, he gave permission to the claimants to appeal the exclusive licence point, and he refused Mylan permission to appeal on validity. Now, as my lords know, and just in the discussion I had with my Lord Justice Arnold, 2 days later, on the Technical Board of Appeal revoked.
No.
Oh, sorry. No. Okay.
You're abandoning it.
Okay. Well, my friend is right. The Technical Board of Appeal held that the patent was invalid for an insufficiency argument raised by Mylan in the EPO proceedings in September that hadn't been raised for the opposition division. And as my lords will know, that the practice of the Technical Board of Appeal is to pronounce a decision with reasons to follow. My clients then abandoned the appeal after that, which is a procedure that is available to them at the EPO, and therefore reasons do not follow after that, and the patent is revoked. And that is a procedure that is allowed for by the rules of the EPO. The new argument I've come to briefly, I don't think we need to spend too much time on it. There is some argument about whether it was or wasn't raised in the UK proceedings. It's called the lay patient insufficiency argument. In effect, it's that the data in the patent do not render plausible an improvement in non-restorative sleep as opposed to sleep generally. And if my lords need that to look at that more detail, Mr. Justice Mead discussed that in the Joint Authorities Bundle, tab 15, page 9.
Mr. Lickitopoulos, are the formal minutes of that hearing, are they in the bundles anywhere?
Yes, they are. I've seen them. I can't remember where. They're definitely there.
So you can tell me something.
Yes, they are.
Tab 19.
I'm afraid I didn't.
Tab 19.
Yes. Yes. Supplementary bundle tab 19.
Thank you.
No,
19.
I mean, I'm not sure my lord will get a lot from them, but they are there.
322 is the substance of it.
Yes.
There's a long hearing on day 1 through to 5 to 7.
Yes, and then you see the board's opinion was announced and the appeal was withdrawn.
Exactly. So in fact, the minutes don't tell you what the opinion was, but they tell you that the opinion was announced. And the appeal was
Well, I hadn't gone to
no one's doubting what happened.
No, I hadn't gone because I hadn't found them very illuminating.
No,
but,
no,
they are there. Now, my lord, just before I then turn to the main issues for today, I should update you on what's happened since then. Following the revocation of the patent, in light of this new argument, the parties returned to Mr. Justice Marcus Smith, and he made the order that is now one of the orders now under appeal. My lords will find that in the exclusive licence core bundle tab 9, and really, my lord will see from tab 9, page 94. That it records in the recitals what had happened at the EPO and the effect of that. It records that in light of that we accepted on termination of the first claimant's appeal.
Forgive me, Mr. Lickitopoulos. I think to have a complete picture, one needs to look first of all at the order of the 30th of December, which is tab 7.
Of course,
because that's the one that set aside the 16th of December orders, and it also contains some quite important recitals, particularly on page 89. And I'm thinking about the last 5 or 6 recitals, starting with what happened at the Technical Board of Appeal, which is recited, and the release of the defendants from their undertakings. And then in particular, of some importance is the recital in the middle of the page between the 2 hole punches upon the claimants accepting the right of the first claimant's withdrawal of its appeal before the Technical Board of Appeal and accepting that the patent has been revoked ab initio, that the claimants are not entitled to any substantive relief against the defendants in respect to the patent whether by way of injunctions or by way of inquiries to damages or accounting profits or otherwise howsoever.
My Lord is right. That to point to that recital, my Lord, we say that's correct in that substantive relief for patent infringement we're not entitled to. If my Lord is putting to me that actually the otherwise howsoever would cover costs, we say that's not how it would be read. That isn't, in our respectful submission, substantive relief that flows from the patent being revoked ab initio. It's not a point that has been taken, but we also say it wouldn't be fair to suggest that the recital there, if that's what's behind my Lord's comment, means that actually the claimants...
No, what's behind my comment, since you raised the question, is that recital accurately stated the legal and commercial reality as at that date.
It's certainly the legal reality.
And also the commercial reality, which is your clients got nothing as a result of the proceedings in terms of excluding their competitor from the market.
At that stage, at that date, the competitor was not excluded, that is right. And my Lord, as I'll come to, in relation to costs, we say nonetheless, when I show you the judgment, and in the context of how the costs were spent, we say that actually if you want to ignores the judgment, as the judge did, one is also not taking the reality into account. And the reality was that Mylan took 2 bites at the cherry, as the EPC permits, lost on one, and the judge said they had reasons why they did it. They lost on one, but haven't had to pay for that. And they then had their second bite of the cherry, but they haven't had to pay. Indeed, they've been paid for the one on which they lost. So, my Lord's right. The only reason I quibble is the commercial reality. If that takes into account what actually happened on costs, we say that is important in the context of a costs order. But I'll come to that, my Lord, in a moment. So, but my Lord is right. This order stands there and revoked the earlier orders, and then the judge came back and made the order that was made on 12th of March, where he reversed his costs order, and I'll come to that, and therefore made my clients pay the costs of the trial, all the costs, and also refused permission to appeal on the exclusive licence. And on his reason for that was essentially that it was now moot based on the revocation of the patent. Now, since then, a divisional patent owned by my clients, EP443, has granted on the 30th of June. And so my lords know what has happened since then, and it will be partly the subject of an appeal happening directly after this one, I believe, before my lords. It is that my clients amended the provisions of the exclusive licence in December in order to meet the criticisms that had been made by Mr. Justice Marcus Smith of the existing exclusive licence. And my own friends accept that the new licence, as of December 2020, meets these objections, but they say that it is still objectionable for the reasons they raise in their respondent's notice. And so there remains an issue of Flynn's right to claim damages prior to December 2020 and potentially going forward. My client sued Mylan under the divisional and amended the claims to be in a form identical to the patent, the subject of the trial judgment. That expires in August this year, and my clients requested an injunction. My client's position was that following the trial judgment, a claim of this scope has been found to protect a valid invention in the United Kingdom, and in light of those findings, Mylan is infringing and ought to be kept off the market until expiry. The preliminary issue came before Mr. Justice Mead as to whether or not my clients were permitted to amend the patent in such a way, Mylan saying that it was either an abuse of process or abuse of dominant position, and whether, if amendments permitted, an issue of estoppel arose in relation to trial judgment. And Mr. Justice Mead held no to both of those questions, and he sent the case back to Mr. Justice Marcus Smith to determine infringement and validity of the amended divisional patent.
Now, just before we proceed on to that, am I right in understanding that neither side appealed Mr. Justice Mead's judgment?
I've just been updated that Mylan did apply for appeal the abuse judgment, and permission was refused, I think last Wednesday, I understand.
Right. Sorry, when you say refused, by this court or by the judge?
By Mr. Justice Mead.
Right.
So
it could potentially still on its way.
Potentially it could. I can't. That's why not ready for me to say. It's a delight that potentially is coming. What did happen, my lord, is Mr. Justice Marcus Smith rejected the lay patient argument that had been before the EPO on the evidence at the UK trial. He said it would not have succeeded, and he said he did not need further evidence on that, and he reaffirmed the conclusion that the claim was valid and infringed based on the findings of the trial judgment, as well as taking account of the lay patient argument. And an injunction was made. That is under appeal to my lords. I think my lords will be hearing that this week after this. I don't want to encroach on those arguments now, obviously. In their appeal application, Mylan is requesting, one of the things it's requesting is a stay of the injunction pending the EPO opposition to the divisional patent. So, whilst resisting the stay prior to trial, to come onto the market, they would like one now. But that is a matter my lords will have to consider, I believe, on Wednesday. With that introduction to the history of this, if I may turn to the licence issue, and then I'll turn to the costs. The licence issue arises because Neurim granted Flynn an exclusive licence in respect of the authorised medicinal product protected by the patent, Circadin, and any generic equivalent of Circadin. The parties to the licence agreed that in any infringement actions they would be commenced and prosecuted jointly with Neurim in the driving seat, that way, and I will show you the provisions, and made provision of how costs would be split. And the issue on the appeal is whether that agreement relating to the mechanics of infringement actions eroded the exclusivity of the licence so as to render it actually non-exclusive. And that was the finding of the judge, and I will show you that. The second issue arises on the respondent's notice and relates to the meaning of an exclusive licence under section 131 of the Patents Act. The judge originally gave us permission to appeal. As I've shown you, my lord, after the revocation of the patent, he held that permission to appeal was no longer appropriate because the issue was moot. My own friend now accepts in his skeleton that the issue is not moot. Not only do we say it's an important point generally, but also the licence covered more than one patent, and it covers the divisional patent, and it covers Flynn's ability to obtain compensation for infringements committed prior to the amendment of the licence in December last year, and subject to the respondent's notice point potentially going forward. So there's no dispute now between the parties about whether it's moot or not. The issue is one of the substance of the point. And if I may turn to that, the real substance is the effect of section 67 of the Patents Act. Now, before turning to the statutory sections, which we must look at, I would like first just to look at the licences themselves so that my lords know what they say, and they are in the exclusive licence supplementary bundle, tab 1. My lord, there is an existing 3122 order covering these licences and amendments, save where the provisions were discussed in the judgment below. And I understand that everything I'll be discussing today I can read out. I think it's not covered by the 3122. We may need a further one, my lords, subject to my lords, for the amended statement of case on the licence issue, which has gone in tab 2 of this. I wasn't proposing to spend time on that now, save to ask if it's possible for a pro tem order now, and if necessary, to either have that or not have that when we get to the form of order. My lord, is that a reasonable way to proceed?
Sounds plausible to me. Yes.
Thank you, my lord. So going then to the licences themselves, and the first one is in tab 1 of this bundle. And this is from, this is how it originally was set up. And you'll see, my lord, on page 9, paragraph 3.1 is the grant provision. And at 3.1, my lords will see that Neurim grants Flynn, which accepts under the Neurim patents, a licence. I'll show you that was then changed to an exclusive licence, but at this stage it was a licence to distribute the product in the territory for use in the field at a term. And so my lords can just see the how those are defined. My lords will see Neurim patents on page 7 at the bottom. Patent rights owned by Neurim listed in Schedule 1. That is the application to what has become the patent, and then any patent rights effectively covering the product, and you see how patent rights is defined of divisionals and the like, and SPCs quite broadly. Product, one sees further down that page, is the prolonged release prescription product containing 2 milligrams melatonin, known as Circadin, and it refers to the marketing authorization. And then the other term that may be worth keeping in mind, the 2 terms, is both the distribution and the territory. The meaning of distribution is on page 6, 2 up from the bottom, meaning importing, distributing, promoting, marketing, selling, or offering for sale Circadin. And then finally, territory, my lords will find back on page 9, which is effectively the United Kingdom and Arnold. Now this licence was then amended, and one finds the first amendment in tab 3 of 22nd of January 2020, and for the purposes of the appeal this is the important amendment, and we can pick it up on page 44 of the bundle. And the grant provision 3.1 was replaced with reference to an exclusive licence to distribute the product in the territory. And there's no dispute either in the judgment or in my own friend's argument that isn't sufficient to be exclusive to all persons, including the patentee. The arguments being raised are slightly different ones. We then go on to the argument that matters, or the provisions that mattered to the reasoning of the judge, and that is new paragraph, clause 3.7, which amended 17.2, which was the mechanics of prosecution of infringers. And the points, just to bring to my lord's attention, are in 17.2.2, the joint enforcement right. The parties have agreed that they will jointly take the appropriate steps to enforce any Neurim patent. You then see, one sentence down, that Neurim shall take steps, including initiation, prosecution and control of any suit proceeding legal action by counsel of its own choice, but subject to the later provisions. But each party shall have its own solicitors on the record and recover the costs on its own account. And then in the next 17.2.3.1, we see that Flynn agrees to be joined as a party, plaintiff or defendant, depending on jurisdiction, to prosecute the suit and claim the maximum amount of damages, etc., etc. And then importantly, we say at the bottom, provided, however, that neither party will be required to transfer any rights, title or interests in or to any property to Flynn or any other party to confer standing on a party. So we say there was no transfer of rights. This was about how to handle enforcement procedures. And then we see that goes on, and I won't read it all out, but one sees in 17.2.3.2 that Neurim will take the lead on certain issues, the parties will work together on other issues, they'll jointly instruct barristers and the like. And at 17.2.3.4, Neurim won't settle any claim without prior written consent, not to be unreasonably withheld. And 17.2.3.5 deals with how costs and damages should be allocated and that both parties would be able to claim. And that's why we're here, my lords. It's the very fact that this agreement continues to allow Flynn to proceed to claim damages is the concern that my own friends have. So, my lord, that is the amendment, and we'll come back to that just for completeness. In the next tab, my lords will see there is a further amendment that took place in May 2020 to the definition of product. And one see that at 58, page 58. It adds any generic equivalent or version to Cicadin. By that stage, of course, it was known that there could be generic equivalents, and that was put into the exclusivity of Flynn. Now, my lords, with that, having seen the licences, if I may look at the statutory provisions and then make submissions on them. And those, my lords, it's easiest to pick them up in the Joint Authorities bundle, but the judgment has some of them in, but not necessarily complete, and so it's easier just to take them, if I may, from tab 26 of the Joint Authorities bundle. And it's page 370. Where there is excerpts from the Patents Act and from the interpretation section, 130. And my lords will be familiar, but on page 371 is where the definition of exclusive licence is given. And this matters both for the appeal and for the respondent's notice. And one sees it just a few lines up from the bottom of page 371. A licence from the proprietor for a patent, a licence from the proprietor of or applicant for a patent, conferring on the licensee, to the exclusion of all other persons, including the proprietor, any right in respect of the invention to which the patent relates or application. So that is the definition of exclusive licence. And we say, as of 22nd of January 2020, Flynn was granted an exclusive licence in the UK and Ireland to the exclusion of all others to import, distribute, promote, market, sell or offer to sell Cicadin. And from 19th of May 2020, also any generic equivalent or version of Cicadin. And we say that's a valuable right. It gives exclusivity to the authorised medicinal product covered by this patent in the UK and Ireland. Now, the judge held that the licence failed to confer exclusivity due to the operation of the enforcement proceedings in clause 17, which I've shown you, and that was because, he said, the effect of section 61 of the Act. And my lords will see that on page 362 of the bundle. And section 67(1) provides that the holder of an exclusive licence, so stopping there, it's already using the term that I've just shown you as to what an exclusive licence, holder of an exclusive licence is and how it's defined. The holder of that shall have the same right as the proprietor to bring proceedings. So it grants a statutory right that, as we shall see, was not there before the 1949 Act. It gives a right to be able to bring proceedings in respect of any infringement committed after the date of the licence. Section 67(2), we say, recognises that you can have more than one exclusive licensee, because in awarding damages or granting any other relief, the court shall take into consideration any loss suffered or likely to be suffered by the exclusive licensee as such as a result of the infringement, or as the case may be, the profits derived from the infringement, so far as it constitutes an infringement of the rights of the exclusive licensee as such. So there can be infringement, obviously, that don't encroach on the exclusivity. They may fall within the claim, but they don't encroach on the exclusivity. And thirdly, this isn't a right that one can bring, the exclusive licensee can bring proceedings by himself. In any proceedings taken by the exclusive licensee, the proprietor shall be made a party, but if made a defendant, shan't be liable for costs. So the proprietor will always be a party, either as an active claimant or as a defendant. Now, we say that there is nothing
Well, before moving on, shall we just, for the sake of completeness, while we're here, pick up section 125, which is at page 368.
Yes, Mylan was right, and that explains that the invention is as set out in the claim. Now, we say that this section does, as it says it's going to do, give the holder of an exclusive license the same right as a patentee to bring proceedings. But we say it is silent and is not concerned with the mechanics of how any infringement proceedings will be conducted and leaves that to the party to determine. And we say that nothing in the license agreements encroaches or erodes the meaning of exclusive license that I've shown you earlier on. Flynn remains an exclusive licensee, but has agreed as to how it will implement or how it will, the mechanics of how it will use the right, the statutory right given to it under section 67. Now, the meaning and effect of section 67 has also been considered by Mr. Justice Pumphrey, as he then was in Dendron and Spring Form. There's no dispute, I don't think, both parties quote Dendron.
Well, surely what he says in Spring Form is much more helpful. But leaving that aside, before we get into the case law, can you help me on this? All of the authorities that are in the bundle of authorities, and all the ones that I've ever seen cited, are all first instance decisions. I have not been able to track any decision of this court on the exclusive license provisions. Is that right?
That is to this side of the court, yes. Obviously,
it seems slightly remarkable, but there we go.
It does.
There has to be a first time for everything.
I have to say, the fact that my lord hasn't found any makes me feel
Reassured
about my own abilities. And I'm going to go leave court today with at least that smile on my face, if nothing else. My lord is right. And looking at the authorities we have, my lord is right. We've got the High Court. And also, I was going to say I wasn't going to take the courts to Dendron because I think both sides quote it, and I don't think there's a dispute. And I'm not sure it takes the argument that much further. Mr. Justice Pumphrey there, as he then was explained, that the effect is to put the exclusive licensee in as good a position to start proceedings for infringement and prosecute them to judgment as the patentee. But he wasn't looking or wasn't concerned with the issue that's before my lords. He did say more in Spring Form, and it may be worth just reminding the court as to what the learned judge said in that case.
Yeah.
And that is in Joint Authorities tab 23. It's in tab 23. This was an issue that arose, preliminary issues, I think, after a finding of infringement, and the question was whether the claimants could pursue pre-grant account of profits. There were issues on the effect of non-registration of an exclusive licence, and also whether an exclusive licensee could take a different election on damages or an account of profits from the patentee. And I believe we can pick it up at page 310. The learned judge set out section 67 at line 20 and said that the purpose of the provision is to assimilate an exclusive licensee to the patentee for the purpose of bringing proceedings. He then sets out the definition of exclusive licensee that we have looked at in section 130, and he says the definition is essential to understanding subsection 2, which I show my lords, because there can be more than one exclusive licensee under a patent, as there is more than one right in respect of the invention. And as my Lord Justice Arnold pointed out, or pointed me to the provision, the invention there is the scope of the claim, but there could be more than one right in respect of it. He said, in my judgment, this term does not merely relate to a list of ways of infringing the patent, set out in section 60, which are not described as rights, but to any subdivision of the monopoly conferred on the proprietor. And we rely on that and say that's correct, and we will do so particularly for the respondent's notice, that it's any subdivision of the monopoly. And what goes on is, when I come to it on the respondent's notice, my learned friend then in our submission takes an example he then gives and rather elevates it to a statutory restriction. What Mr. Justice Pumphrey went on to say is to take an example proposed in argument. In the case of a pharmaceutical product, one manufacturer may have exclusive license effectively for veterinary purposes and the other for humans. The veterinary licensee has no interest in recovery in respect of human products, although he has a cause of action in respect of them. Subsection 67(2) is directed to ensuring that the exclusive licensee obtains compensation, to use a neutral term, only where the infringement affects his slice of the monopoly.
But on that example, you could perfectly well have a claim that covers both of those uses. So it could be, for example, a claim that includes the word animal, which will include human.
Exactly. We agree with that, and we say there's nothing wrong with that.
Or more specific, or could say mammals, which again would include a human.
That's right. And we say what's important is that the license that's given to the exclusive, which gives him his field of activity, is exclusive, is not encroached. So what his field of activity is, in this case, for instance, it is circadian and generic equivalents. What matters is that he has that right exclusive to anyone else. Not, and we say that that is entirely supported by what Mr. Justice Pumphrey says here. Before we leave this case, it is also, my Lord should see what he said about the right, and that really, he did that in the context of making an election for damages or an account of profits, and he said that came up on page 312 at, really starts at line 25, where he was considering what happens if you've got two plaintiffs with concurrent causes of action for damages, the patentee and the exclusive licensee. Does the provision mean that they each have to take the same election? And he said, in my judgment, it clearly does so. The exclusive licensee right is the same right as that possessed by the patentee. On the other hand, he goes on to say, well, if my lords will just read to the bottom. And the point I was going to draw out is he preferred the view that there's common cause of action with the patentee entitling him to recover compensation for his own loss. And again, we say nothing in the agreements between, or the agreement between Neurim and Flynn affects that, and Flynn continues to have an ability and a right to recover compensation for its own loss. So, my Lord, with that, we should look at how the judge dealt with this and why he said that there was a problem. And for that, one can go to the main judgment, which is in the core bundle, tab 11. Page 193 is where we can pick it up. Paragraph 145, he said that the provisions of the licence, which I've shown you, my lords, essentially take away Flynn's ability to prosecute a claim he said at 45.1 that Flynn has no right to bring a claim independent of
Well,
Newey.
before we get into that, we've also got what he says at 142, where he sets out what one might call a starting point, that section 67 says it's a consequence
Yes.
of the grant of the exclusive licence, and the right to bring proceedings for infringement is not expressed to be a necessary condition for
Yes.
exclusivity. And you submit, I take it, that that's not really a starting point, it should be the ending point as well.
Well, I was going to, you've taken a different order than I was going to, but we've got to the same place, my lord, yes. We say that is the starting and the end point, and effectively encapsulates our appeal. But I need to show you, of course, why the judge did not agree with that. And on that, at 145, he said that Flynn has no right to bring a claim independent of Neurim. And then in 2, 3 and 4, he goes through the provisions we've looked at. But then he comes to the nub of it in 146. And if I may just ask my lords, rather than me read that out, for my lords to read that it yourselves, and then I'll make submissions on it, if I may ask you to do. Well, my lords, first, we say what had originally been said to be no right to bring a claim independent of Neurim, in paragraph 146 has become, in the middle by the lower hole punch, that Flynn has no rights independent of Neurim. And then he's gone on to say that the grant provision of clause 3.1, when read together with the enforcement provision, means in reality that Flynn has no rights independent of Neurim and has been effectively deprived, the grant provision, of substantially all meaning, and gives an entirely misleading view of Flynn's rights. He says actually the exclusive rights of Flynn have been eliminated in a substantive way. And with respect to the learned judge, we say this is just can't be correct. He seems to have lost sight, with respect, to what the grant clause 3.1 was all about. The grant of clause 3.1 was about exclusive rights to do the acts of distribution to Circadian in the United Kingdom and Ireland, and that has not been altered in any way at all. And it's not right to say that that's not independent of Neurim, it is, and it's not right to say that clause 3.1 has been deprived of substantially all meaning. It, with respect, plainly has not. Secondly, that the judge said that what is being prosecuted is a single cause of action, and we've seen that in Mr. Justice Pumphrey's decision in Springfall. But that's not a reason why the licence is non-exclusive. Indeed, as I've explained, Flynn continues to have the right to pursue its damages, and that's why we're here and arguing the point before my lords. And thirdly, even under section 67, an exclusive licensee doesn't have an independent cause of action to take actions by itself. He shares the cause of action with the patentee, and we say that nothing in these agreements has eroded the exclusive licence at all. So we say these are material errors in paragraph 146. In our submission, what the judge has done is he's lost sight of what the grant of clause 3.1 was all about. Now, if we're right on that point, then the appeal ought to be allowed subject to the respondent's notice point. Now, in the skeletons, we address the respondent's notice points in our main skeleton, followed by them without doing sequential. And I'm happy to address you on this now if it's convenient for the court, or whether you prefer first to hear my learned friends. Learned friends, I'm in my lord's hands, but
I suspect you're not going to be that long developing these points, are you? In which case, why not develop them briefly now?
Okay, my lord. I will do that now, and so my lord at least understands the points and
yes.
what my learned friend has submitting. My own friend calls this salami slicing, and the point is this. He says that Flynn has exclusivity to Circadian and generic equivalents or versions, but the scope of Claim 1 and of the patent, and obviously other patents which are covered by the agreement, is wider, potentially. And he says there are what he calls residual parts of the claim which are not within the exclusive grant. Now, paragraph 31 of his skeleton, he accepts that his point isn't you can only have one exclusive license per claim, but he says that a license becomes non-exclusive where the invention, i.e. that which is claimed, as opposed to its exploitation, is shared or subdivided between two or more people. And I'll have to let my own friend develop exactly what that means, but what he said, it seems, that it's permissible to divide out acts or markets, but you must work the invention to its full scope. Now we say this is entirely contrary to the words of the statute, which say any right in respect of the invention, and is contrary to what I've shown you from Mr. Justice Pumphrey, we say in spring form, and we commend that. As it arises in the current case, what my learned friends have done is they posit various potential different products that could be within the claim, but not within the grant of the exclusive license. So they say that there could be melatonin formulations which are not generic equivalents of Circadian, or they could be rectally or parentally or administered or inhaled, and therefore wouldn't be generic equivalents. They don't exist, but they say they could.
Do you dispute that?
Well, I don't dispute that, but we say none of that arose.
I mean, so your point is that the judge was wrong when he says, you accept, I think, 140 sub 2, that the examples put by forward are second medical uses within the patent, not at the same time within the exclusive grant of Flynn. You accept that's wrong. You say it doesn't matter.
We say it doesn't matter. I mean, actually, it's not so clear to us that in the end the judge in our submission seemed to be saying that he would have had problems with the claim as granted. He thought that would have gone away with the amended claim. It's not entirely clear in my submission that he is actually saying they don't exist, but we say it doesn't matter. So we say that the important point is that none of that erodes Flynn's exclusivity. And if such medicaments did exist, Flynn would still have exclusivity over Circadian and generic equivalents of Circadian. Pointing to other products that are not within that grant doesn't erode that. And we say that's at the end of the point. My own friend says no and says otherwise, and the way he gets there is what he says is, in our submission, a limiting construction on the meaning of exclusive licensee in section 130 of the Patents Act. Now, I've shown you that, and it's actually written in broad terms, but he says that actually it should be restricted, and he gets there by way of the Swan Report 1947 and the 1949 Act. And I will show you that briefly and then move on. That is in Joint Authorities Bundle, tab 32. In tab 32, my lords will have a 1947 report from the President of the Board of Trade to Parliament, and it was part of the report that led to the 1949 Patent Act. And the points where my learned friend relies on is, we can start on page 419 of the bundle, because the issue had arisen about fair compensation for exclusive licensees, and you see there in 129 that where a patentee grants an exclusive license, it's usual to include a clause permitting the licensee to use the name of the patentee in infringement. And it says then, from the point of view of the exclusive licensee, that's not altogether satisfactory. Although the action can be brought in the name of the patentee, it's properly constituted in law, the redress obtained might be inadequate. And so in the last sentence you see that in such circumstances, as the law stands at present, the exclusive licensee has no means of recovering compensation for any loss he may have suffered in consequence of the infringement. So the proposal was that this disability should be remedied and the law amended to enable an exclusive licensee to sue in his own name and to obtain compensation for damage he sustained, as well as other relief. So again, it's enabling him in the way that we've seen and seen discussed by Mr. Justice Pumphrey in Springfall. Over the page, the part that I think my own friends like to rely on is paragraph 134, where the Board of Trade said that when using the expression exclusive licensee, they say it does not denote only a licensee who is solely and exclusively entitled to work the invention in its entirety in the United Kingdom, but as comprising also any person who has sole right and exclusive right to work the invention in any particular field of its application or in any particular geographic area. And in effect, on the respondent's notice, my learned friend is asking my lords to read those words into the Patents Act 77 and then say that that isn't what's happened to Flynn. And we say neither's correct. Just to finish...
Well, presumably you would say it doesn't hurt you even if it is read in, because in any particular field of his application can be read in having exactly the same meaning as Mr. Justice Pumphrey gave the statute in Springfall.
Exactly. Yeah. That's exactly our point, my lord. Just to finish it off, my learned friends have then gone on to show how this then links to the 77 Act, and just for completeness, you'll find that link in the core bundle, tab 20. No, sorry, 19. Tab 19. What you'll have in tab 19 is first a supplementary skeleton, and then behind it, starting at page 269, they put in some a second reading from the House of Lords on the bill that became the 1949 Act. Oh, is it House of Commons?
Misleading.
You're absolutely
Looks like
right.
House of
It
Lords,
is misleading because it says Lords, but it's House of Commons. But my lord will see at the point that my friend
Wilson was...
Yes, yes, he was. I've just seen that.
He went to the Lords rather late.
Page 270 is really, there are two bits that my learned friends rely on, just so my lords have them. The first main paragraph on 270, the last sentence starts fitly, and it's saying that what the proposal is, it gives additional rights to the holders of exclusive licenses under patents, which is true. And page 272, first main paragraph, they explain, third line, under clause 35, he, and that's an exclusive licensee, may institute proceedings for infringement of the patent, rights which hitherto could only be exercised by the patentee. And we have no difficulty on this side of the court with those, we just say that it doesn't take matters any further. And certainly you don't see any discussion here about some restricted meaning to exclusive license in the Act. And what was then enacted, my lords have on page 284, which is the Patents Act 49. And you see at the bottom of the page there the definition, which we're very familiar with, a license any right in respect of the patented invention. And that wasn't changed in the 77 Act. And I had a brief look at the bank's report, and I couldn't find any reference to discussion about exclusive licensee, which accords with the fact it wasn't changed. Tab 20, what we've put in just historical interest, is the first publication of Terrell after the 49 Act. So my lords will see that's the 1951 Terrell, just to see what contemporaneously people thought had been going on in the 49 Act. And one sees that over the page at 287, where the authors of Terrell write that the Act of 1949 has given to an exclusive licensee an important new right, viz. To take proceedings in respect of infringement in his own name. The patentee, if he does not join as a plaintiff, must be added as a defendant. It then says an exclusive licensee means a person who's been granted by the patent some right. I've shown you the actual statutory wording was any right, but the authors of Terrell, we say that means the same thing. Some right in respect of the patented invention, the exclusion of all others. And then they say there may therefore be several exclusive licensees, each having an exclusive license in his own field, and each may sue in respect of the infringement committed in contravention of his particular right. And we commend that. And we say exactly right. And that's exactly what Flynn has. It has exclusivity in its own field. And that accords with the statutory language in 1949 and 1977. It accords with the purpose of the new provisions, and it accords with what Mr. Justice Pumphrey, he then was, said in spring form. And we say, therefore, there is nothing in Mylan and Friends' points on the respondent's notice. Well, let's say I can help my lords further. I was going to move to the costs provisions.
Mr. Clark, just one thing. It's I understand what you've said, but what I want to be reassured about is implications for other areas. So you will know that exclusive license rights for exclusive licensees to litigate is not something unique to patents. It happens in other intellectual property rights. I think also the Enforcement Directive refers to rights of licensees to bring claims. You haven't gone into any of that, so I take it that means that you've thought about it very carefully and it will have no implications whatever we do in this appeal to other things like copyright, for example.
My learned friend I was going to make submissions on his respondent notice on the Copyright and Trademarks Act, and I was going to wait for him to make those because, to be fair, my lord, I wouldn't like to say I've spent a lot of time thinking about the Enforcement Directive angle, and I can do overnight, and I wouldn't like to say to my lord
I can't remember what it says, but I'm pretty sure it says something.
Yes, it does. I hadn't thought it was material, but that doesn't mean it isn't, and I will of course check that. In relation to potential knock-on effects, we would say that my lords would need to be very careful if one goes down the route that my learned friend is suggesting, because that could have far-reaching effects. If one imagines a patent with a claim covering a number of compounds, or a Marcouche formula or something, on my learned friend's analysis, it would not be possible to grant exclusivity to a specific compound covered by the claim. One would have to, and the one that may have marketing authorization and be the subject of SPC protection, one would have to grant exclusivity over all of them. But he says you could split them out with fields of application or geographic scope, and that comes back to what he means by field of application, which I've had a discussion with my Lord Justice Arnold. We don't see that as a material distinction. And we also would mean that if you did have two compounds, two molecules, you wouldn't be allowed to grant exclusivity to one person to molecule A and another to B. And in our submission, if one's not careful, my learned friends would lead to effectively a potential proliferation of divisional applications, because he says you have to grant exclusivity to the whole scope of the invention, and that the invention must be tailored to that right. Indeed, he's very open about that. And that means the claim must be tailored to the grant given. And that we raise in our written submissions raises issues about how one could do that. It's about the scope of the claim, equivalence, understanding the scope of the claim when one grants the license. But also, it may well provoke a plethora of divisional applications. Because under my learned friend's proposal, it's perfectly fine if one then obtained a load of divisionals with slightly different scopes of claim tailored to your exclusive license. And we say, not only is that not in the public interest, but it does rather show the arid nature of our learned friend's point. And so we say, actually, to the extent public policy comes into it, we say it is firmly against my learned friend's respondent's notice point.
Can I just try to understand implications of this? So suppose it is indeed the case that you can't have an exclusive license for a particular compound, but nevertheless something that looks like an exclusive license is granted in respect to that compound, and then there is infringement. Who, if anyone, can recover loss?
My friend's point is that only the patentee can bring proceedings, and only the patentee can recover loss.
And only for its own loss.
And only for its own loss, exactly.
So if the patentee has granted the purportedly exclusive license in respect of the individual compound on a basis that his income is secure come what may, no one can recover for loss.
That's right.
Yeah.
My lord, that is the exclusive licence issues on appeal and respondent's notice. If I may now turn to the costs appeal. We accept, as we must, that there is a high burden on us to appeal a decision of a first instance judge on costs, and that it requires an error of principle, or overlooked material factors, or is in some ways in the legal basis perverse, going beyond the broad discretion that even the generous boundaries given by CPR 44. We accept that. But we say the judge here did fall into such errors that justifies the court considering the issue fresh. And I was going to split my oral submissions into 5 points that cover our grounds of appeal. The first is we say the judge was wrong to revisit his December order in thinking that the EPO result was a material change in circumstances as regards costs.
Well, can I be clear as to exactly how you're putting it? I assume you're not contesting that he had jurisdiction to do so.
We're not. We are accepting he's got jurisdiction.
Right. So in what sense do you say he was wrong?
We say that when exercising that jurisdiction, he should have done so considering he should have taken into account whether the change in circumstances had a material impact on the costs order made.
Do you say he should have disregarded the revocation of the patent altogether?
We say the end result is yes, in the sense that the costs were all spent on the English litigation. That's how they were caused, and Mylan lost on all of them. Alternatively, we say...
So let me be crystal clear. I repeat my question because I'm not totally clear that I understood your answer to it. Do you say, and I want a yes or no answer to this, please, do you say he should have completely disregarded the revocation of the patent?
My lords, I don't have a yes or no answer. The reason I'm paused is because I accept that under CPR 44, all circumstances can be taken into account. So I don't think it's right to say to my lord, any particular circumstance can be ignored.
Well, that can't be right, because whether it's a full moon that night is a circumstance, but it's plainly irrelevant.
We say it is irrelevant to how the costs were spent and the costs of.
Right, so you say it's irrelevant, and therefore he should have disregarded.
Yes, my lord, on the first ground, on the first point, he should have disregarded.
An immaterial consideration.
It's an immaterial consideration to costs. If my lords are against me on that, then it must be taken into account. And the question is, where does it fit? And that's my second point, my lord, is what we say went wrong, is it became the only matter that he took into account in relation to who was the successful party, and in effect, then ignored the trial judgment. So my lord has just put to me, was it wrong to should he have ignored the EPO? If I'm wrong on that, we say he certainly should not have ignored the trial judgment.
I mean, you're obviously going to develop these points. The difficulty there is it's binary. At the stage where you're choosing a winner, you have to choose one or the other. If you're going to take it into account at all, then it rather suggests that there's been a change of winner.
And my lord's a fair point there, which is why our third point is that, of course, CPR 44 is not just who is the winner, it also says another order or an alternative approach. So the who is the winner approach is not the be-all and end-all of CPR 44. And that's our third point. And our fourth point is that to the extent he did take other factors into account, and I'll show you he did say other reasons I should take into account, again he did not look at the trial judgment at all. Instead he looked at the events that I've briefly gone through with the EPO, and we say effectively placed all cost risk on Neurim and relieved Mylan of that risk. And we say that is an error of approach. My fifth and final point is even if Mylan is held to be the winner and prima facie entitled to costs, and there are no other circumstances that change that, he was wrong with respect not to proceed with an issue-based costs order. And we say, in effect, what's happened is if Mylan had succeeded in the UK, an issue-based on the one point of the EPO that they won on, an issue-based costs order would almost certainly have been considered.
Okay, now I've got those 5 points. Can I, so as I can see where we're going, how do they fit into your grounds of appeal? Your point 5 is clearly ground 3. Your point 1 I understand to be ground 2.
Yeah.
So are the points 2, 3 and 4 varieties of ground 1?
They're all in ground 1, my lord.
Sorry?
They're in ground 1.
Right, okay, they're all within ground 1. Thank you.
And my lord will know that ground 1 was also amended with permission.
Indeed it was. Thank you for reminding me.
And that's where specifically we raised also the point that I've just discussed with my lord on 44.22b of a different order. Now, before turning to the 5 points, my lord will obviously have picked up that we say that an error was to ignore what actually happened in the judgment. And before then going to develop the 5 points, it is important in my submission to see the judgment and see what actually happened, because it does in our submission impact on the proper assessment of costs. And my lords will see that in the appeal call bundle, tab 11. And I think you can pick it up on page 106. And on page 106 at paragraph 7, you see that by trial the issues were all on validity. Infringement was not a separate issue, and so if the patent is valid, Mylan accepted it would infringe. But then we see the issues that were run on invalidity, and one sees the first one was novelty over Heimoff 1995. That was the attack that succeeded at the opposition division of the EPO, but the Technical Board of Appeal did not consider. Then, at little 2, you see that obviousness is run over a number of citations. Heimoff Melatonics webpage and a document, an article called Zizappel 1999. So 3 obviousness citations. And then a number of insufficiency points. And my lord, the judge set out classical insufficiency, excessive claim breadth insufficiency, and uncertainty insufficiency, and lack of plausibility insufficiency. And then he sets out the pleading at the bottom of page 110. But the first point is akin to the point before the EPO. There's a debate between the parties as to how much that was actually the same. I'm not sure that matters for today, and indeed the judge has since found that that little A3A point they would not have succeeded on. And then they also ran ambiguity, and then we see classical insufficiency. So a number of insufficiency points were run. Now the other point that we say is important to keep in mind, and again the judge didn't factor into the judge's analysis at all when he came in March to consider the costs order again, was what actually was said about Mylan's case and how the costs were spent. And on that, one must see page 115. This is where the judge talked about Mylan's expert, Professor Morgan, who was an expert witness. And if you turn over to page 117, little h, you will see that the judge was extremely critical. And it's not just a sort of criticism that one might often see in judgments. In our submission, it's much more trenchant than that. He says that Morgan 1 and Morgan 2, so those are the written reports on which the costs were spent, were in critical respects disingenuous documents, written in a manner that seemed to me calculated not to assist, but to mislead the court. I'm very conscious this is the most serious criticism that one can make of an expert, and I do not make it lightly. And he says at the bottom, I am not confident I can rely on his reports, save with a degree of caution and reserve the judge would not normally attach to the report of an expert. And I'm not going to show you all the examples to that. There's one example, my lords will get a flavour, in paragraph, page 147. Sorry, let's go 153. At 153 at paragraph 67, he's talking there about a very important, obviously an important point. Professor Roth, as our expert, was clear that at the priority date there was no treatment for non-restorative sleep, and no recognition that melatonin might play a role in successful treatment. Professor Morgan's evidence on this point, I'm sorry to say, is not satisfactory. That evidence was in the first place nebulous in the extreme, and to the extent that Professor Morgan could be understood to be advancing clear propositions, they were unsupported by other evidence before me. And he gave two examples, one of which is on page 161. And he set out a number of paragraphs of the written evidence to which the costs were spent. And then at 161, he explains why he has. And at little e, he said it's necessary to be absolutely clear what these paragraphs are going to. They are written in support of the proposition that in advance of the priority date it was well known the administration of slow-release melatonin, 2 milligrams, would, at least in older people, improve quality of sleep. Obviously, this is if not the, central point going to the patent's validity. And in consequence, this is a proposition to which I have unsurprisingly paid considerable attention. Unfortunately, Professor Morgan's assertion is supported not by evidence, but by a melange of irrelevance and, frankly, misdirection. And he goes then through red herrings, and what he says at the top of 163 can only be described as misleading citation of material. And at 164, little f, he does not think failure to cite certain papers could be justified. Now, this is Mylan's evidence in chief on which the costs were spent, but it forms no part of how the judge then came to look at costs when he came to revisit the issue in March, because in our submission it was all about the EPO order, and only about the EPO order, and interaction between the English case and the EPO. And what got lost is that actually these are sort of criticisms that are more trenchant than one normally would see in a patent action, and Mylan has been awarded all their costs. And when we look at the conclusions on page 195, at paragraph 148, he concludes the challenges, and I've shown you all of them, to the validity of the patent all fail. They all fail. Their expert had significant criticisms that relate also to how the expert evidence was prepared and therefore costs, and yet they've received all of their costs. And we say something has gone wrong and justifies re-looking at the issue. Now, with that, my lord, I was going to then look at my first point, which was his revisiting the December order. And we referred in our skeleton to a judgment of my Lord Justice Birss in Optus and Apple, where my lord explained, obviously the leading case is Tibbles, there must be a relationship between the change of circumstances and the conclusion that has been reached. But he explained that the correct approach when assessing materiality is if there's a relationship between the change of circumstance relied on and the conclusion reached, and he referred to Processing Centre and Pitney Bowes. That is in the bundles at JA tab 16, paragraph 11, but I don't think it's an issue, and therefore, if my lords wish to see it, it is there. The judge considered the issue in the judgment, and I should show you, my lords, that, because he did consider whether or not it was right exercise of discretion, and that is in core bundle 12, page 227. And what he said at paragraph little d on 227 is that he thought that the hearing before him on the 16th of December was, if not explicitly, then certainly implicitly, conducted on the basis that any orders made could and would, if appropriate, be revisited. And we, as I from my discussion earlier with Lord Justice Arnold, we accept that, and also that that was considered in the order itself in relation to the relief that we say would fall away if the patent's revoked. And as my Lord Justice Arnold pointed out, there was a sunset provision in the injunction clause. Now, he points out there that he said one example will suffice, and he points out that it was said at the hearing that the EPO appeal does have other implications, and that there was a suggestion by Mylan that if the EPO was to be unsuccessful, then costs of the trial posts would need to be revisited. At that stage, he said he disagreed and was surprised to hear that would be the case. And we say that his provisional view was correct, and that the revocation in the EPO, being as it was despite of, not because of, the English litigation, should not remove all cost orders.
So, let's take it in stages. Suppose the patent had been revoked by the EPO the day before Mr. Justice Marcus Smith would otherwise have sent out his draft judgment. So at that stage, you wouldn't have seen what was in it, nobody would know what was in it, and the action would come crashing to a halt. Could you, in those circumstances, say that the revocation of the patent was irrelevant, and that he should proceed and deliver the draft judgment that he had by then prepared?
I think, my Lord, in those circumstances, one might well ask to have the draft judgment handed down. My Lord, I hear my Lord on...
But why? Why would he hand down a draft judgment in circumstances where it's academic on the substantive issues?
Because in our submission, it's not academic on costs. And again...
But suppose he exercised his discretion not to hand down the draft judgment.
Well, my Lord, then I accept that if you don't know who's the winner, different issues arise. But my Lord...
Okay, well, let's start a little bit further back in time. Suppose he hasn't finished writing the draft. Suppose he's halfway through it.
My Lord, in my submission, that would mean it would be a difficult situation to be debated with the judge at that time.
So you're accepting that the revocation of patent must necessarily be relevant in such on that hypothesis?
Well, on that hypothesis, there's nothing else, my Lord, at all, because you haven't got a judgment, you haven't got anything in the UK, and all you've got is an EPO revocation.
But the costs have all still been incurred.
My Lord, that's right, and that's why, my Lord, I'm saying that actually I could see that in those circumstances one might have to ask the judge to consider the issue.
So you're seriously submitting that if the judge has half written the judgment and the patent is revoked by the EPO, he's got to go on and finish writing the rest of the judgment? Are you seriously making that submission?
I hear, my Lord, that is not falling on good grounds. How good, happy ears. My Lord, what we are saying in these circumstances, my Lord, we do have a judgment, and we do have the findings of what happened in the UK, in the English proceedings, and we say it is not right in those circumstances to move on the basis as if they did not happen. There may be cases where they did not happen. I accept there may be difficult cases, other cases, but here it did happen. We had the judgment, we had the results, and we say it's not right not to factor them in.
But why is it equally right not to factor in something which also plainly happened, namely the patent was revoked?
Well, the main reason, my Lord, really, is because that I'm not suggesting one pretends that the EPO didn't happen. It did. But did it affect costs? And that's the whole thing is in the context of costs. So, my Lord, I agree.
So costs are incurred for the sake of it, are they?
No.
The whole reason costs were expended was because you were trying to enforce the patent, which conferred a monopoly, which allowed you to charge a monopoly price by excluding your competitor. That was the object of the action, and it failed.
Well, my Lord, the other way of looking at that is that we had little choice because Mylan would not wait for the patent to either be removed by the UK court or by the EPO. They wanted to come on early. They did that for their own commercial reasons. As a patentee, we cannot sit back and just let that happen with a patent that's expiring in August 2022. They took their own risk. They plainly wanted, and the EPC gives them this, they plainly wanted 2 bites at the validity cherry. So they wanted and had benefit to having an expedited trial, and I've shown you the correspondence, in the UK, so they could try and revoke the patent here, and they would try and revoke it at the EPO. We say it's wrong in those circumstances to take the EPO as the be-all and end-all and ignore the UK. Effectively, what one's giving them is the benefit of 2 bites at the cherry with none of the risk. Whatever happens in the UK, if they win in the EPO, they get the cost back. It's a sort of no-brainer, to use the phrase, to go in the UK. But actually, it's more nuanced. They had come on the market.
So in the Zodiac, Virgin and Zodiac litigation, Zodiac should have been able to keep the 49 million. Or in fact, that was their claim rather than that it was actually assessed. But let's assume that it had actually been assessed.
Well, the difference in my submission, my lord, is that in that case, that goes to whether or not they can rely on the fact of the revocation in a damages inquiry.
And your submission is that what happens in the EPO is completely irrelevant.
Well, my lord, my submission is also one has to take what happens in the UK into account. And also, my lord, we say that unlike in Zodiac, what's going on here is an assessment of who should get the costs of what happened in the English litigation. Both sides proceeded for reasons of their own to have an expedited trial here, and they lost on all the issues on which costs were spent. And we say it's wrong then because they won in a parallel jurisdiction on a point it's not even clear was being run in the UK, and when it was advanced in the UK, the judge said they would have lost on. But they get all their costs. And if it's not... Oh,
sorry, go on.
Sorry.
Can I just explore that one moment? Suppose the UK litigation had been about just one ground, and that same ground had then succeeded in the EPO. What, on your case, would the position have been?
My lord, and that is, I accept a wonderful position from my perspective, and I agree that's because costs, it's hard to do costs on points of principle in a grand way in that sense. One has to look at the facts of the case in our submission. In that submission, if there's one ground in one and one ground in the other, we still say that the English judgment should be taken into account because it may deal with conduct, it may deal with other issues. What we're saying goes wrong is just to simply go with the EPO.
But that's not your first point. Your first point is you say what happens in the EPO is irrelevant.
I understand that.
It's moonlight. It's a full moon.
I understand that, my lord, and I understand that's not going down well with my lord, and my lord's accepting that. My lord, that isn't our only point, and I accept...
Well, yes, but are you maintaining? That's the question, because you're putting forward lots of arguments to say that what transpired in the English proceedings was relevant. That, of course, is a point which may have great attraction. But at the moment, you're on point 1, which is what happens in the EPO is irrelevant. So that's where we're struggling.
Understood, my lord. We say, I think that maybe the difficulty is it's the binary point of relevant or irrelevant. It certainly happened. We say it's not a material factor that justified changing the result. That's what I'm looking at under the barrels or CPR. So, my lord, in one sense, is pushing me to say yes or no to something that I actually, in my submission, isn't, with respect, the right answer, right question. My point isn't irrelevant or not relevant. It's, is it a material factor to the costs decision? And in taking that into account, we say it isn't a material factor. It is something that happened, but we're saying in terms of costs, it is not a material factor, it's not the material factor. We say the costs consequences should not change. And I'm doing that in the consequences of this case, and I accept my Lord Justice Newey's point, there may be other cases, just as the other way around happens, where you could have huge numbers of points run in the UK and one simple added matter point run in the EPO. And again, it would be wrong to go just one way or the other.
Can I be unfair and stick for a moment with the hypothetical situation, which, as you say, has not arisen? So there's one point in the English litigation, and the same point wins in the EPO. Now, at the stage at which you choose a winner, it is binary. So, does the fact that ultimately the one side has won in the EPO mean you have necessarily to choose that side as the overall winner?
We don't accept it necessarily have to. We would say it would depend on the facts of the case, because although I accept in that situation it's much closer, there may still be issues in the English proceedings that mean it's not right. But my Lord is right that
Why?
the winner...
If you have regard to the EPO at all, how do you avoid the conclusion that the side that won in the EPO is the winner? There may be all sorts of other things that reduce the extent to which they get cost recovery. But if you're choosing your starting point, which is who is the winner, either you ignore the EPO or you have to decide that the person who won in the EPO is the winner, don't you?
Well, I think on the situation my Lord has put to me, I can see that it's much more likely that you would say that. And in fact, that's again, one would then look at whether or not that's the right approach or whether another order is necessary. Yeah. On our case, we say actually, because of what's happened in the UK, it's a more extreme case actually against Mylan. But I do take the point, my Lord. I can't stand here before you and say in all cases one just goes and ignores the EPO, and nor am I trying to suggest one ignores what actually happens. And if I may now move, my Lord.
I'm sorry, Mr. Clovis, I know you want to move on, but can I just make sure I've understood something, because it's only the penny's only just dropped. What you're making submissions about is materiality in the sense of being, as in to justify reconsidering under 3.17.
Yes.
Which is, at least on one view of that judgment of mine and Tybalt's and everything else, not the same question as merely something that you would take into account in the exercise of a discretion before giving an order, making an order.
That's right.
There's a lower standard, if you like, of materiality before you make your order than there is of material enough to justify reconsidering it.
That is right.
And you're talking about the latter.
I'm talking about the latter.
Okay. Thank you.
Now, my Lords, if my Lords are against me on that and say he was right to exercise his discretion to take into account in the way in deciding who's the winner and to use that approach to costs, we say that what he then did wrong in with respect was entirely ignoring the judgment in doing so. And effectively, there's no discussion on either conduct of the parties or on revisiting the order about what actually happened in the English judgment. And what actually goes, the pendulum has swung entirely the other way. And so the pendulum has gone to EPO is everything. Subject to some EPO-related conduct issues, which I'll show you, and he effectively said neither side should be criticised. But effectively, the pendulum swung. And we say, again, that's not right. The pendulum shouldn't just swing entirely the other way. And in the end, we say that's not ignoring real life, it's viewing success in the context, understanding that the patent was revoked, but it was revoked in a parallel jurisdiction on a different point, and bears no relationship to how the costs were spent in this court. And we say, therefore, in those circumstances, he should not have held that Mylan was the winner, or if he still felt that actually one can't call us the winner because of the patent being revoked, albeit outside of the UK proceedings, then this would be a case for a different approach as is provided for by CPR 44, and he did not approach it that way either. If I may show you how he approached it, then my lords will see where our criticisms lie. and that is page 234 of the bundle. And at paragraph 73, he asks who is the winner and says costs should follow the event, and the event there is now at the EPO and the revocation of the patent. And you can pick up actually his conclusion on why in paragraph 78 that the interaction that exists between EPO proceedings and the UK proceedings, the result in real life in this case is to be determined by comparing the remedies and relief with what they actually obtained. And stopping there, of course, the remedies and relief that Mylan obtained was actually despite the UK litigation, not because of it. And that's how he then did it. Viewed through this prism, there is only one winner. And we say that prism is too blinkered when considering costs properly, exercising the discretion. As I say, that is the pendulum swinging one way only.
Well, there's two separate questions here, aren't there? Firstly, there's the question of who's the winner, and then secondly, there's the question of once you've identified the winner, what order should flow in the circumstances of the case. Now, if he's right to have regard to the result in the EPO, why is he not right to identify Mylan as the winner for the reasons that he gives? I appreciate you say that doesn't dictate the result on costs because there are reasons, you say, for nevertheless making a different order. But at the stage of identifying the winner, what's wrong with this reason?
My Lord, we say that when identifying the winner in the context of costs provision, one should take into account more than just the remedies and relief in circumstances where the remedies and relief were not resulting from the English litigation.
But you were seeking an injunction and delivery up and damages or an account of profits, and you got none of that. Moreover, as you've already accepted, you didn't achieve the commercial objective of excluding the competitor from the market. So whether you view it in legal terms or commercial terms, you failed.
Well, whether we succeed in removing the competitor from the market is, of course, still unknown. But
in this action, on this patent, you failed.
That is right. Well, my Lord is right, but we failed not because of what happened in the UK. Well,
indeed, but you failed. So where's the reasoning wrong in terms of identifying the winner?
And the reason, my Lord, as I've said, is that we say the winner is identified in the context of the English litigation. But if my Lord...
Well, if you disregard the EPO entirely, I can understand that submission. But at this stage of the argument, we're assuming that you've lost on that. If you can take into account the result in the EPO, what's wrong with this reasoning?
My Lord, if we can take account of the EPO, we say that there's nothing wrong with the reasoning that where one looks at the remedies and relief sought, there is only one winner. That is correct in relation to the remedies and relief sought. It is not, we say, the whole story. I think that's my Lord's second point, that when one then looks at, well, should costs then follow that event, which is the remedy and reason event, we say that wrongly ignores what actually happened in the UK. And that, we say, is important in a costs consequence, because the only reason one's asking these questions is to see, well, how were costs spent and how should they be awarded? And I understand that's my Lord's second point, as my Lord has divided them up. But one can see that the judge saw it in a binary way from paragraph 80, where he rejected an issue-based award, and that's obviously our third ground. But he said the usual alternative of an issue-based costs order is not appropriate. The fact is the issues all go one way or they all go the other, depending on whether one looks at the outcome as stated in the judgment or the outcome in the new order that I will in due course make. So in other words, an issue-based cost order is not particularly helpful.
Right, so this raises an important question which seems to be in dispute on the skeleton arguments, which is, was he asked to make an issue-based cost order? And what I mean is not was the idea floated in passing, but was there a positive submission to the judge that even if you decide, from your side this is, even if you decide that Mylan is the winner, Nevertheless, you should depart from the normal order of all costs following that event, but make what is commonly done in patent cases, namely an issue-based costs order, and in particular the obvious issue-based costs order that one might have thought could have been argued for would be to say that they get just the costs of the plausibility argument and none of the other costs.
Well, I'll come to that. We say it was in our skeleton. My learned friend accepts that what was requested was not the plausibility argument. It was at the stage my clients still don't accept, that that had fully been raised in the UK. Since then, that's been looked at and failed later. What was put was an issue-based costs order that all costs come to us, save for the exclusive licence point, and that is an issue-based order.
Can you show us that in the transcript, please?
Of course, my lord, I was going to come to that, but if my lord goes to supplementary bundle, tab 11. This is our skeleton argument for the form of order hearing.
All right, you want to do that before the transcript?
Sorry, I was going to do a skeleton argument. I'll get reference to the transcript.
All right, let's look at the skeleton first. That's fine.
And it's on page 240 of the bundle. And little 7 in the middle, it said even if a new issues-based assessment, so that would be a new one, doing it again, is the right one, then the claimants should have their costs, bar on the exclusive licence issue, the defendants having lost on all the invalidity issues they elected to litigate in the UK proceedings. And we say that is an issue-based because we won on everything validity, other than, and of course we didn't win on the exclusive licence. And my lords will...
Sorry, I don't understand that. Then the claimants should still have their costs, bar on the exclusive licence issue. So the argument is not for an issue-based order at all. It's you're asking for everything. Because you go on to say the defendants having lost on all the invalidity issues they elected to litigate in the UK proceedings. So it's not an issue-based assessment.
Well, in our submission it is, because they did lose on all invalidity issues they ran in the UK proceedings.
It's just another way of framing the argument that you won on everything.
That's because we did, my lord. I mean, I know that sounds like I'm being facetious, but
it is supposed to be an alternative argument, not the same argument repackaged.
Well, my lords, in the circumstances of this case,
maybe it's clarified in the transcript.
I'll look for the transcript, my lord. But in the circumstances of this case, we did win on everything, and as my lord will remember.
So, was the judge supposed to understand from this that what you were contending for in the alternative was that if you were wrong in your submission, that you were the winners and not Mylan? Even if he came to the conclusion Mylan were the winners because of the patent being revoked, he should proceed to make what is generally understood to be an issue-based order, namely whereby you allocate issues according to who's won on issues, even if they haven't won overall. And in the present case, you would then have to see where the commonality was between the EPO proceedings and the UK proceedings, and it has to be in the area of insufficiency, and you can argue about where in the area of insufficiency the commonality is. But how is the judge supposed to understand that that's what's being advanced?
Well, my lord, you have what's written there. We would say, though, that my lords will have this, it's not in dispute. There's no suggestion that the later EPO decision means that the judgment was wrong. And my lords will have that from ASIA and the Court of Appeal, and my learned friends, I think, accept it.
Just sticking with your skeleton, Mr. Doppler, as I understand it, what you're saying is, your point is that this, in your skeleton, contemplates that what the judge, one of the things that the judge should do is do an issue-based assessment. You then do the horse trading and say that in fact if you do an issue-based assessment you won on all the issues, so it comes to the same thing. But
Yes.
you're contemplating that an issue-based assessment is the way forward even if you're not the winner.
That's right.
That's what this is.
That's what this is.
I mean, the last sentence of subparagraph 7 may possibly help. The idea that all these costs should now flow.
Yes, it does. I mean, my Lord Justice Birss, that's our submission. But in the circumstance of this case, we say it comes to the same result.
But it may or may not. But you say you can do an issue-based assessment, and you also say, and if you do, you get to the same result.
That's
Someone
right.
might disagree with the second thing without disagreeing with the first thing.
Exactly. And as I was just submitting, there's no suggestion, and my Lord and friends accept that the EPO does not render the judgment wrong on the decisions, and that's ASIA in the Court of Appeal.
We don't accept that at all.
Oh, sorry, my Lord. I thought my Lord and friends accept. I was saying my
I
Lord.
don't think they do accept.
Oh, I thought they quoted ASIA. My Lord, if one goes to ASIA in the Court of Appeal,
And there's the small question of how it's to be reconciled with Smith and Nephew, or more fundamentally with Virgin and Zodiac.
well, my Lord, I think that what Justice Floyd was saying in ASIA, where it was a request for a cross-undertaking for damages, for injunction, he said there that the later EPO case does not render the English judgment wrong.
Indeed, he did say that. But the question is, how would you reconcile that with Virgin and Zodiac, which says the opposite,
Well,
and how you then reconcile it with the subsequent decision on Smith and Nephew?
my Lord, in our submission, not saying the opposite. I mean, what happens in the damages inquiry, again, it all goes to the fact of the revocation can then be relied on in a damages inquiry, and the fact that it's ab initio. But again, isn't saying that the judgment is wrong, or the reasoning was wrong. The fact of the
Well,
revocation.
Let's have a look and see what Zodiac actually says, shall we?
I just wonder, Ms. Liquidopoulos, whether actually this point really helped here, in the sense that if you've got to this point, it's because it's been accepted that it's proper to have regard to the outcome in the EPO.
Yes.
And it's because it's been accepted that the outcome in the EPO means that you are the overall loser. To have a debate then as to whether the English judgment is wrong seems
I understand.
a bit arid.
I suppose the reason I mentioned it was it goes behind why our submission was below, that an issue-based order would continue to be costs of validity go our way and of the exclusive licence go against us, subject to this appeal. That was the purpose of it.
Yes.
So it's not that we say, oh, well, now it's been shown that the judgment was wrong. That's not the approach. And I also accept, my Lord Justice Birss, that my own friends or the judge will not accept that on an issue-based, or may say, I'm going to look at the issue-based again. I accept that. I'm not saying that that's not possible to do. What I'm saying is what the judge did is say it doesn't arise. And
Since it is relevant to all of these questions, I think we should have a quick look at Zodiac. It's paragraph 27 in particular. So this is Authorities Bundle tab 25 at 342.
yes, indeed, my Lord. And the defendant was not stopped from asserting or relying on the invalidity.
And that's despite the fact that there was a final decision of the Court of Appeal saying that the patent in its unamended form was valid and infringed. So to use the language of the judge in our case, the decision of the Court of Appeal in that case was trumped by the subsequent decision of the
Yes, my Lord, that's what the judge said, and my Lord has it that in the Court of Appeal in ASIA, in paragraph 9, said that revocation of the EPO would not show our judgment to be wrong, or the judgment to be wrongly granted.
And how do you reconcile that with what's said in paragraph 27 of Zodiac?
Because in our submission, the court in 27 isn't saying that the judgment here is wrong, it is saying that it's open to rely on the fact of the revocation. And so we say doesn't go to the, what we're talking about here would be the costs and the reasoning that went to the issues. So was the judge right on point A or wrong?
Sorry, Mr. Thomas. I think that if I've understood what you're saying, I think your point is that Zodiac makes it clear what the effect of the EPO revocation is. But that doesn't mean that, for example, you could stand in court on an issue-based costs order and say that the decision that the patent was not obvious was wrong, given that the EPO hadn't held it was obvious, the EPO had held it was insufficient. So whatever the effect of the EPO's decision is, it doesn't mean that every single issue that was fought out is one of which you are now on the wrong side.
That's right.
There's a point about sufficiency, because of course they decided it was insufficient, and you could get into an argument about granularity and how far you go into that. But subject to that, that's what you're talking about
That
when
is
you
right.
keep saying it's not wrong.
That is right. So, my Lord, Lords, then we
Just,
look.
sorry, before you move on,
No, of course.
we got to all this from paragraph 80
Yes.
of the judge's consequentials judgment. So the judge says he doesn't think that the usual alternative of issue-based costs order is appropriate. And he says the fact is that all the issues go one way, or they all go the other way, depending on whether one looks at the outcome. Now, this may be a point for the other side, but I'm not sure I understand that. I mean, the whole point of an issues-based order is that you don't take it that everything went one way, you look at the issues individually.
That's right. And we say that what this flows from in our submission is because he was looking at it only from the prism of relief. So on the relief, it's pan revoked, pan not revoked. And that's why we say he's saying it's the pendulum swings one way or the other. And that is our third ground of appeal, as you appreciate.
Now, can you help me on this? As we've discussed, the argument presented in the Skeleton argument was that actually the cost analysis is the same, even on an issue-based assessment, which is a concept I have difficulty with. But suppose the right answer is that there should be an issue-based assessment, and that therefore what one is seeking to do is to have regard to the respective degrees of success of the parties, both in England and in the EPO. And as we've discussed already, the overlap comes in the area of insufficiency, and in particular in the area of plausibility. Now, I think you've accepted that the judge wasn't invited to make that assessment. But is it your submission that this court is in a position to make that assessment, and if so, how?
It's not, my Lord. I don't think this court is in a position to make, well, it depends on granularity. The court is in the position to know that the judge did look at the insufficiency point in the UK and held it was, that Mylan lost on it, would have lost on it, and did not lose on it. So he has looked at that and said they did not succeed.
Sorry, that's in a subsequent judgment in completely different proceedings.
Well, on the same claim and the same judgment.
And he doesn't say, because he could not say, that they didn't succeed in the EPO.
No.
So that's just repackaging your submission. You get everything. But I'm asking you to assume, for the purposes of my question, that you lose on that submission.
Understood.
And so the question I'm asking you is, suppose this court considers the question of what might properly be termed an issue-based assessment, namely, that reflects the degree of success of the parties overall. And the question then is, how is this court in a position to make such an issues-based assessment on the materials that we have?
Accept that, my Lord, and that we say, I think we said in our skeleton, would be something that should go back to the trial judge to do. We say that isn't a waste of cost and time, because it is one issue.
So you're accepting that this court can't do it, but you say that's not a problem, we remit it to the trial judge.
Well, my Lord, I accept, but what you don't have before you are the issues as to the granular nature of the issue and also the costs.
Well, exactly. So
I have to.
do we even have the starting point? Because as you will be well aware, the normal way in which this is done in the patents court is each party comes to court with a breakdown of the costs on each issue. So one knows in percentage terms, within a degree of margin of error, how much it has been spent by each party on each of the issues. And it's typically done by page counting and skeleton arguments, paragraphs in the experts' reports and paragraphs in the judgments. So did the judge even have that material?
My lord, I'll just...
No, he didn't.
I don't think he did, my lord. And I was just checking that.
But if the judge didn't have that material, how would a remission help you? Because the judge would still be lacking that material.
Well, my lord, if our appeal succeeds, we say then it is appropriate to do an issue-based cost survey, and that should be done.
But I'm sorry, if you're going to come to court at first instance, arguing, albeit in the alternative, for an issues-based cost order, the first thing you've got to do is put forward the judge the materials to enable him to make an issues-based assessment. And what you're telling me is the parties didn't do that.
Well,
so it really was all or nothing on both sides before the judge.
Well, no, there was the issue-based that I've shown you, which was the issue-based of... I think the point Mylan was putting to me is the insufficiency point of the EPO and how that factors in.
No, it's a breakdown of the percentages you've spent on each of the issues in the English proceedings. And as I understand what you're telling me, is that nobody put before the judge the materials that is commonly put forward. So commonly, as you well know, one has witness statements from each of the solicitors in which they say, on novelty, it was X percent, on obviousness, it was Y percent, and on insufficiency, it was Z percent. And they arrive at those percentages by paragraph counting, typically. And there's always a margin of error, but it's rough and ready, and it does, and that's what one uses when making an issue-based cost order. But you're telling me that that wasn't done in this case.
Well, it was done in relation to the exclusive licence point versus validity.
But only for exclusive licence?
That's because before the judge, my clients were working on the basis...
so it was all or nothing when it came to validity?
On validity it was, because that was based on the judgment.
So even if we remitted it to the judge, he wouldn't have the materials?
Sorry, my lord, I'm just being asked. May I just take instructions
Sure.
briefly? Right, my lord, I'm managing to look at this overnight, but my learned friend is saying that my learned friends gave an estimate of 18% of the validity would be on the EPO point. So, my lord, there is...
You need both sides.
Well, to be fair, my learned friend put that forward, but I accept, my lord, I'll look overnight, but to my understanding, we didn't have it from our side.
I suppose there's also a difference between making what is normally done, which is a percentage order, and just making an issue-based cost order. One could simply make an order saying that somebody or other gets the costs of everything except, say, validity or sufficiency. That's always a possibility. We try not to do that for obvious reasons, but that's something that...
My lord is right. It doesn't have to be a percentage deduction. It can be issue-based. Obviously, as we all know, there are reasons why percentage deduction is preferred, but it's not prescribed.
And you'd certainly prefer Mylan split to the existing order.
Well, no, I'm being told. My lord, rather than be whispered things and maybe get them wrong, I prefer to look at the issues that my lord has raised on what was actually put in terms of costs breakdown.
And also, you need to look at the transcript to see what the judge was actually asked to do.
I understand that, my lord, and I prefer not to do that on...
No, I was just looking actually at the index to the transcript for the consequentials hearing. I see there are 3 references to issues-based from which one may or may not get something.
Yes, there are, but I prefer to make submissions, if I may, once I am looking at the time. I think it will be more helpful submissions if I do them in the morning rather than, if subject to my lord's agreement, rather than doing them now with whispered things that I might get wrong, frankly. My lord, we have jumped on though to the third ground of appeal, and I was just going to the judgment, and I can finish this off this afternoon, just on our first ground of appeal and how he then used the.
I'm sorry to interrupt you when you're just getting going. I just want to pursue a thought before I forget. My Lord Justice Birss put forward a helpful suggestion, which is that to get over the difficulty of the judge not having had the materials to do the conventional percentage assessment that's done, one simply has a true issues-based order.
Yes.
And the question then is how that would then be framed. And all I'm asking for is what would be your submission as to how such an order should be framed if we go down that road.
I understand.
Again, you might want to come back.
If I may, because I have ideas in my head at the moment, but I prefer to think about them and come back with that. Well, just finalising on the judgment and just on our first ground of appeal, which is how he then approached it. We looked at paragraph 80. In 81, he did then say he needed to consider whether there are other specific factors in play that could justify a different costs order. But the factors he then looked at were all effectively to do with the interrelationship with the EPO rather than what had happened in the English proceedings. And it all goes to the outcome-based approach in terms of relief that had remedies and relief. And one can pick that up and see that when one gets to conduct. He got a heading on page 238. And effectively, he talks about the conduct of the proceedings and says that neither party was effectively blameworthy on that, he says. And at 88 in specific, he thinks the conduct of Mylan, presumptively successful party, did not cause him to alter the incidence of costs. And he explains why, because he says in the end, both sides, for their own reasons, decided to take a risk on costs in the UK. And you see that at paragraph 89. He says both Neurim and Mylan knew about the hearing at the Technical Board of Appeal. He inferred that one or both of the parties did not want an adjournment and can understand why. Mylan, for its part, would have wanted 2 bites at the revocation cherry, and Neurim, having failed to obtain an interim injunction, would have wanted a final injunction in place as soon as possible in the event of succeeding in both proceedings. The quickest way of achieving that was by maintaining the expedited trial while pressing on with the EPO. So he's found that both sides had reasons for pressing on. And in terms of the cost...
do you challenge that? There's nothing in the grounds of appeal challenging that.
No, I'm not challenging that. I don't challenge that. What we do say, though, is what we say is 2 things. One, he's overlooked the fact that we did actually suggest a stay at the outset. And secondly, the way he's then dealt with the cost risk is effectively all on us. And on that...
if you're relying upon stay, what's your answer to the point that the effect of that would have been to keep Mylan off the market until December the 18th, whereas in fact they were able to get onto the market in September, and so far as this patent is concerned, justifiably so. And you never even offered a cross undertaking.
My lord, they didn't ask for not a cross undertaking, we didn't get that far, but my lord...
You didn't offer one, so it goes round the circle.
Well, my lord,
Neither, as we discussed at the outset,
yes.
neither party addressed the question.
I accept that. Neither party. So, my lords, then at page 240, we see how he deals with the risk, and that's at his little 3. And what he says, you can pick it up about 5 lines down. In my judgment, in not seeking to engage with the court on the question of adjournment, each of the parties assumed the risks of costs being wasted. Stopping there, we say that actually a proper, a fair analysis is therefore each party takes the risk and they lost on the issues that were before the court here. What he then goes on to say is, and of a costs order being made that followed the outcome of the interaction between the UK and EPO proceedings as opposed to the reasoning. And we say that's not a fair assessment of taking all circumstances into account in saying that's really just saying the risk was on us, because he then goes on to say, it seems to me that Neurim cannot now complain that it bears the entire cost of the trial, because although the judgment favoured it, the outcome of the interaction between the two proceedings has resulted in them being the losing party. The UK proceedings costs were thrown away. That is something that Neurim could have avoided, and I consider there's no reason why I should alter the costs I have reached. And we say, actually, it's found that both parties had their own views of doing that, and both parties took the risk. And at 92, he says, I make clear I'm no way singling out Neurim for particular blame. At the outcome of the interaction between the EPO proceedings and the UK proceedings favoured Neurim, I were to consider that a provisional costs order in the UK ought to favour Neurim. I would have considered Mylan's failure to raise the matter for adjournment in the same way. And with respect, although the judge thought that he was dealing equally or fairly between the parties, in fact, it's in our submission it can't really arise the other way around. And with respect to the judge, that doesn't follow, because what he's done, in fact, is saying that if we had won both, we'd have got our costs, but the moment we lose in the EPO, we do not. And that is actually removing the additional cost risks of Mylan, of having 2 bites of validity. Whatever happened in the UK, they could potentially get their costs if they won in the EPO. So we don't accept, we say the judge, whilst he thought he was keeping the point neutral, in fact it isn't, in the way he has dealt with it. And we say that actually Mylan was prepared to take the cost risk of having the judge's phrase 2 bites at the validity cherry. It lost on one and won on the other. But it hasn't had to pay the costs of the one it lost, and it got its costs on the one it lost. And we say that is what's actually at the heart of what's gone wrong here, and actually is out with a fair assessment of discretion on where costs should fall. Now, my lords, we're almost at 4:15. I was going to suggest, if I may, that I consider the points that my Lord Justice Arnold has put to me overnight. That will be a very short, I suspect, tomorrow morning. It won't take me long, I don't think, to make my submissions on those points. And then we're on good track for finishing the appeal at lunchtime tomorrow, if possible.
So the practical question is, do we need to start before 10:30 in the morning?
I think I'm looking to my learned friend.
Yes. So suppose that, how long do you think you might need in the morning? 15 minutes or more than 15
Probably
minutes?
15, 20 minutes at most, I would have thought.
So on the assumption that Mr. Liquidopolis takes 15 to 20 minutes, do we need to start earlier than 10:30?
Well, I thought I was going to be about half a day. Given the comments I've heard from the bench, I suspect that the first half of my respondents' submissions are going to take a bit longer than the second half. But it may be better, maybe safer to start at 10 o'clock.
Well, in that case, let's do that. So we'll break now and we'll start at 10 o'clock in the morning.